Hey, hi everyone. For today's episode, we are going to cover something that is known to a lot of individuals, but yet somehow still a bit murky, and that is the lasting power attorney, LPA for short. In Singapore, there is this legal document known as the lasting power attorney, LPA for short, all right, where an individual who is a donor is able to appoint other individual, one or more, known as donees, to act on their behalf and make decisions on their behalf in the event of a mental capacity. When being appointed, right, there are mainly two broad areas where the donees are able to act and make decisions on behalf, namely their personal welfare decisions, and there are also their property affairs. So to give you an example of what are personal affairs are things like living and care decisions on a daily basis, and also their medical treatments or their medical affairs. Some examples of property affairs will include like their financials, their finances, in terms of how do you manage your bank account, making transactions on their properties, so on and so forth. So the thing now is that in the event of a mental capacity where there is an absence of the LPA document, the family members doesn't automatically make decisions on behalf of this individual. The reason is that prior to the mental incapacitation, the family members are not appointed, and hence with this outcome, right, requires the family members or the next of kin to apply to the court for deputyship. And going through this process would mainly hinder the next of kin or the family's member ability to provide care for the individual, or rather the donor in this case. And going through the court will also mean a more tedious, long process, and you will incur more costs as compared to doing up an LPA beforehand. Yeah. So with the statistics, since 2003, there were only approximately about 300 LPAs registered, and up to today, 2023, we are seeing about approximately about 230,000 LPA registered. Although it's a huge jump, which signifies that the general public is seeing the importance of this. But if we were to compare it to our population, it is still rather an insignificant figure. Now, we want to take a look at what is the reason that is delaying individuals to do up their LPA. So it is mainly due to some of the misconceptions, and we want to talk about them in this episode. So Dylan, there is this misconception that LPAs are meant for the elderly. So what do you think of this?
Yes, I think there's a lot of misconception on there, because when we talk about lasting power attorney is to actually prepare for the event of a mental incapacitation, and that usually occurs in a situation where, because of illnesses or old age, like dementia. So a lot of time people relate illnesses, dementias to old age, but that's not true, because the truth is that even for young people these days, they could be mentally incapacitated because of illnesses, because of dementia as well. It's not like dementia is exclusive to elderly. It's actually for young people as well. So I think that is something that people have that misconception that LPA, wait until I'm old, wait until I'm old and weak before I do it. But that's not true. Even for young people these days, we are seeing a growing trend of younger people, in the 30s and the 40s as well, that is actually setting up their lasting power attorney, because there's a more awareness now these days as well. So that's important.
Most definitely, yeah.
And what are the other needs that you think that is LPA actually created by family members? Do you think that's true? Yeah.
Actually, this misconception is definitely not true, because anyone who is at least 21 years old and is mentally capable of making decisions, right, is able to appoint a donee in the LPA. So including friends, family members, anyone that they really or truly trust. So what is more important is to actually choose someone that you can trust enough to act on your behalf with regards to your personal welfare and financial welfare. Yes.
I think there's a misunderstanding. So before you are mentally incapacitated, right? You can actually set up the LPA by yourself.
Yeah. Yeah.
On your own wishes. And when you are mentally incapacitated, that's where deputyship comes into place. Where family members or someone your next of kin actually apply to become a deputy to act on your behalf. But that process is usually longer and more tedious as well.
Yep.
So
yes. So another misconception is that we hear individuals talking about setting up an LPA means losing of control. Is that true, Dylan?
I don't think that is true at all. I mean, like there's a misconception that once I set up my LPA, I lose total control of my own personal welfare. I lose control over my properties, my assets, which is not true because the lasting power attorney, right, the donee only comes into play when you're mentally incapacitated. So when you're a healthy physical individual with a mental sound mind, everything that your own welfare, your own personal welfare, your own assets, is still all managed by yourself. And this lasting power attorney is actually a contingency plan where when you're unsound mind, mentally incapacitated, that's where it comes into effect.
Absolutely.
Before that, it doesn't. So you just set it up in place so that everything is in place before things happen.
Absolutely, yes.
Yeah, and of course, we also have this misconception, right? That once LPA is created, it's irreversible. It cannot be changed. Is it true?
Absolutely not true. Because for an LPA, at a point of sound mind, when you make a decision to appoint your donees and give specific instructions, along the way, if there's any changes, you are able to make change to your LPA, and you can even revoke your last LPA to set up a new LPA document if there is any changes to the donees on the donee's part, or any changes to your wishes, so and so forth. Yeah, so that is what you can do with the LPA. Yeah. So the moving on to the next misconception, which I also hear a lot, is that a lot of individuals have the perception that LPAs are for the wealthy and LPAs are for the rich. What do you think of this?
That's definitely not true, because LPA is not just about managing your property, your assets. That's all. It's also about taking care of your own personal welfare. And I think that personal welfare is not exclusive to the rich or the more privileged. It's actually to everybody, because I think that by setting up this LPA, actually you have a certain wish of how you want to be cared for in event of a mental incapacity, and making sure that you appoint the right person a person of trust, a person where will be able to act in your best interest. I think that's very important as well, because the last thing you want is do not, while you are mentally incapacitated, do not have the standard of care that you will have expect or you wish to receive. So LPA is not just about managing your assets or managing your property, that's all. It's also about your welfare, your well-being as well. So setting it up to make sure that you appoint a person of trust is extremely important. And another misconception that we have, right, most people, I mean generally the public has, is that family members can actually automatically access bank account.
Right. That's absolutely untrue. And it's a very dangerous assumption by family members. If you are thinking that in the event of a mental incapacitation of your spouse, especially, you assume that you're still able to execute financial transactions on behalf of your spouse. That's not true. And you'll be served with a very rude shock at a point in time where bank staff rejects your application to conduct any form of transactions. And this is typically the case study that we see. There are a lot of spouses sees a lot of challenge, not being able to provide timely care and making timely decisions on behalf of their spouses. Yeah, so this is definitely not true. So mentioned earlier at the point of introduction is that if LPA is not in place, then you have to go through the tedious process of applying to the courts, paying huge amount of monies for deputyship, so and so forth. Yes. So next, what we hear is that you can also create LPA after losing mental capacity.
Yeah.
All right. What do you think of that, Dylan?
So I think that is not true, because the moment you lose your mental capacity, right, what happens is that that will happen, and a lot of time people confuse deputyship with appointment of a lasting power attorney, being the donee itself. I think there's this misunderstanding. The truth is that the moment you are mentally incapacitated, right, you will not be able to actually appoint your donee. That appointment, the choice, your wishes, your choice of person of trust to actually be appointed as a donee itself can only be done when you're mentally of sound mind. So that is something that is very important. It cannot be done when things happen. When things happen, that's where you have to apply through the court for deputyship, office of public guardian, to actually get the permission to actually act on behalf. And you have to understand that generally this mental incapacity act, right, actually is in favor of the vulnerable, which is the one that's lost the mental capacity. Because when that happens itself, right, when you apply for deputyship, they will actually look through, assess whether you are a suitable candidate to become the deputy, and they will also require a more stringent set of requirements in terms of how you are going to be caring for that person that is mentally incapacitated. So that is something that cannot. So lasting power of attorney cannot be created when after things happen.
Right.
Mentally incapacitated, that's too late.
Absolutely.
Yeah. So and of course one myth that there is that appointing more than one donee will create conflict. Do you think that's true?
I think for this, it is partially true that it is a concern,
Yes.
right? Because if you are appointing more than two donees to make decisions on your behalf, potentially there may be differences in views, so on and so forth. Which is why for this particular misconception, I would like to highlight and strongly suggest to help you streamline on the thoughts process, right? It'd be good to speak to a counsel, be it a lawyer that you trust, or even your financial advisor who is servicing you or attending to you and your family financial situations, or any issues that's pertaining to that. Because these professionals are able to have a conversation with you early enough so that they provide you with a framework to think about how or who you want to appoint and shortlist the suitable candidates, right, to be appointed as your donees. Now, as much as too much donees can potentially be conflict in terms of times when you need to make a decision.
Yes.
However, there is a plus point to it, which is it actually provides checks and balances. All right, when talking about things pertaining to your personal affair or versus your financial matters, as per se. Someone who is a caregiver to you, who is very good in providing caregiving to you, may not be inclined towards making financial assessment or financial decisions. So you may need someone that is better at this area, right, to help you make decision on their behalf.
Yes, that's right.
All right. So next is for some individuals who already set up their wills, all right, they find that the LPA is not important.
Yeah.
What is your take on this, Dylan?
I think a lot of time there's a more general public knowledge and awareness of setting up of will, and there's some lack of to a certain extent of understanding of lasting a power of attorney, and they feel that is something of lesser priority, which is not true, because the thing is that for will itself, of course, is to manage your estate in event of death itself. In the event of your demise, and your asset actually get distributed according to your wishes. But for lasting power of attorney, it's different. You are still alive, but you are not mentally sound. You are not of sound mind, and you're mentally incapacitated. So also in event of that itself, there is a duty of care by your family and your loved ones. So that it provides a clarity in terms of who should be in charge of deciding on your personal welfare, who to decide on your property affair, your assets itself. So it's very different, because one is the distribution according to your wish when you're no longer living. The other is you are still living but bedridden. So and then you have to have a provides clarity on who to take care of you. and that cannot happen when you're of unsound mind. So that has to be set up in place
Right.
ahead of time,
Right.
just like a will. So a lot of time people think that I set up with my will already. So why is LPA important? So I hope that this sharing today can actually bring that clarity
Yes.
in terms of why LPA is as important as setting up of your will.
Most definitely. Yes.
So and of course, last myth. So which I think this is one of the drags in terms of resistance when it comes to people taking action. To actually set up their lasting power of attorney is that setting up LPA is complicated and expensive. Do you think it's true?
Half truth in my perspective. The reason for that is because it will depend on the complexity of your circumstance. All right. For the LPA, there are actually two forms: Form 1 and Form 2. So for Form 1, it is generally templated a simple LPA. So based on the circumstance, if you feel that the Form 1 is able to meet your circumstance needs, then it is very, very affordable. Furthermore, during this period of time, the government is actually providing subsidies, which is waiving off, they're actually waiving off the administrative fees to register the LPA, which is $75. So on your end, what you typically have to incur as a cost is mainly a fee paid to your certifying issuer. So that could range anywhere between $50 to probably $150 kind. Yeah, so that to me is very reasonable. However, if your circumstance is more complex and you have more wishes, you want to make more arrangements,
more customizable.
Yes, more bespoke. So you have to use the Form 2, where the certified issuer can only be a lawyer, rather to say. Yeah, so that is my take in terms of complexity and whether is it expensive. I would say generally it's affordable for the general public, but however, if you require more bespoke, then it naturally will lead to more cost depending on the lawyer that you're engaging. Right. So moving on, we would like to share a case study, and this case study actually comes from Dylan's personal experience. So Dylan, I understand that you already did up your LPA years ago. So what was it like for you, your thought process, and how do you actually execute that whole LPA process? Would you care to share with our audience?
Sure.
Yeah.
So for me itself, I think it was a realization when I first become a father. So I actually did my LPA about 5 years ago. So that was when I was in the early 30s. So that's very important. LPA is actually not just for the elderly or for the old age, but it's actually for anybody. So there was a thought process that was going through my mind when I make that decision to actually come together with my wife to actually set up our LPA. And that's important because at that point in time, my wife was taking a break from work full time, and I was the sole breadwinner of the family, and I was concerned not just in event of my unexpected demise, but also in a situation where I'm mentally incapacitated, and what will happen financially to my wife, because at that point in time she is not working, and my son is just 1-2 years old, so he was still very young. Okay. So when things like that happen, how will my wife be able to financially cope with such circumstances? Because at that point in time, of course, we have our joint account, but the significant part of the money itself and my assets itself is basically through my individual account, personal account. And that will become a problem because when I'm mentally incapacitated, she will have to apply for deputyship, and for that, her to become a deputy, right, will take between 6 to 12 months. So that means that there will be a 6 to 12 month window where she will not have any cash flows and any access to my personal account. And that becomes a problem, because the thing is that the household expenses still continue to run in that 6 to 12 months. Right. And there's still duty of care to my child as well, and a duty of care to my parents as well financially, because I'm also giving allowance to my parents. So in event where something like that happen, that also come across to my mind. How will my wife be able to cope for 6 to 12 months without any source of working income, because she's taking a break from work, and then limited funds as well, because our joint account do not have much significant funds, and most of the funds actually in my personal accounts, my assets, my investment portfolios, all these things is under my own individual account. So she cannot access to all these things until she get appointed as a deputy, which takes 6 to 12 months. So I think that is a concern because and that is why I decided to actually take action. And I think that the process wise for me when I apply for a lasting power attorney itself, to get certified, it's actually the entire process is actually very smooth and it's fast free and it's not expensive at all. So the cost to me at that point in time when I actually did the lasting power attorney was $80, which I think is a reasonable fee because for just that $80 it takes away a lot of worry and concern that is weighing on my head. Because no matter how young and healthy we are, we do not know where unexpected things happen to us. And the last thing we want is because we delay that process, because we procrastinate, and we feel that $80 is something that is a cost to you, and delay that decision, right? You never know what will happen to how you will impact your loved ones. And I think that the impact is really significant. The procrastination is really significant. So I decided at that point in time, to take action and to make sure that, in event something happens to me, my personal welfare can be taken care of, and then making sure that, as well as not just my personal welfare, but financially for my family, my wife, my child, my parents, they are also financially sound because with the lasting power attorney, my wife will be able to provide that cash flows to the family. So I think that's important.
Right. Okay. So the thing is, a lot of the general public or probably even our audience might be thinking, okay, now I'm ready to do my LPA. So what are the steps involved? Alright. So Dylan, would you care to bring us through this process?
Okay, so thankfully since this year, right, the first few steps can actually be done online. So meaning you can actually log in through this Office of Public Guardian through your SingPass itself to actually set up you can appoint your donee through that. So of course there are a few key considerations when it comes to setting up of a lasting power attorney. You have to establish who to take care of your personal welfare, who to take care of your properties and financial affairs itself. So and of course who are the donee? Is it one donee, two donees? And if it's more than one donee itself, then you have to decide whether it's done jointly or jointly and severally. So that will be the first step to establish that. And after that, subsequently, what happened is after you have already decided on that, the appointed donee will actually receive a notification and they will go through log in through their own SingPass to actually acknowledge their appointment as your chosen donee.
So this whole process thus far is all online?
Yes, this process thus far is all online and it's actually short and simple. If you are guided through by somebody who has actually experience of logging online to actually do the lasting power attorney, the entire steps will take you at most 10 to 15 minutes. So all these things, the step 1 and step 2 that actually I shared with you, right, is actually all free of charge. There's no cost to it. The cost comes in step 3. So once your donee has actually acknowledged appointment as an appointed donee itself, right? That's when you actually bring yourself down to accredited
certified
issuers, to, which can be a lawyer, appointed doctors or psychiatrists as well.
That is for Form 1, right?
That's for Form 1. So that's for Form 1. So then they will be able to actually make sure and establish that you're of sound mind, and then they will certify the issuing of the lasting power of attorney. So this entire step will also be you just have to be physically present, but this will be done online in the presence of accredited certified issuer. So that will be the third step lah. So that itself they will usually charge you a small fee for Form 1 itself to actually certify that. And of course the issuing of the lasting power of attorney, which is the final step by the Office of Public Guardian, will also be online itself, which is the final step, which you don't need to do anything. They will just basically once they certify that the certified issuer has actually established that sound mind when you make the lasting power of attorney, they'll issue it out. So everything is online. So these days everything is I think pretty streamlined,
made easy,
streamlined, and things are a lot easier. Yes.
Okay.
So I think to close off today's session,
Yep.
okay. So it's important to know that setting up of lasting of power of attorney, right, is more than just a legal formality itself. Okay, so it actually empowers you to actually have a control over who you actually choose to actually take care of your personal welfare, to take care of your property and your financial affairs as well. And hopefully, our session today actually dispel some of those myths, the common myths that has actually uh, around that actually causes you to actually procrastinate, to delay decisions on whether to actually proceed with this setting out of this lasting power attorney. And hopefully it creates a clarity over this session today that by setting out a lasting power attorney, you can actually safeguards
Absolutely.
your
Yes.
wishes itself and ensure your well-being is actually being cared for according to your wishes itself. And this is a proactive measures, to actually protect interest and also provide clarity to your loved one as well. Because when you're mentally incapacitated, the last thing you want is actually ambiguity in terms of who to take care of your personal welfare, who to actually take care of your property and your financial affairs itself. So by setting up the lasting power of attorney beforehand, actually provides a clarity to your loved one as well, so that when things happen, the things are already in place.
Okay.
And it's also an act of self-care and responsibility as well, so that your wishes are actually respected, in event of mental incapacity.
Yep.
And it's also giving you a peace of mind as well, that everything has been done already. I do not need to worry about my family members do not need to worry about the ambiguity when something happens to me. And of course, having a financial professionals or professionals to actually guide you through this entire setting up of lasting power attorney, the thought process, the decision making in terms of that itself, it can be tailored and customized in terms of sitting down with your professionals like your financial advisors can be very useful in terms of understanding your needs and concerns, your wishes as well, so that they can guide you through in terms of that decision making when you are preparing a lasting power attorney.
Yeah. Yeah.
So to close off, today, lasting power attorney is not just a legal document. Okay, it's also a statement of autonomy to actually make sure that it shows you against misconceptions and provide you a clarity to yourself as well as to your loved one as well, to make sure that your future is actually well taken care of. So I think that's very important.
Yeah. Yeah. So with this video, we hope that with the information shared and the personal experiences, case studies, it will propel you to have early conversations with your counsel, be it your attorney or even your financial advisors, to help you come up with a streamlined framework, and from there identify the potential donees and have a conversation with them. And this is what we hope from this video that we are creating for you. We hope that this video has been of value to you guys.
Yes.
If you find it valuable, do remember to give a like on today's video, and remember to look for the bell icon, all right, and click subscribe for more of such valuable contents. All right. If not, we'll see you in the next video. Thank you.
Thank you.